Oh, couldn't nobody hear me? Okay, let's see if we gonna get this going on. She ain't never getting nobody, which is like, hey, Kevin. I know. And you know, it's so crazy because I didn't even start the stream. I had it scheduled for one because yesterday they played us all the way, had us sitting up around here waiting for hours and hours and hours, and then they decided that they wasn't even gonna have the case. So I was like, okay, well, this today I'm gonna schedule a little behind time, and then I just got the alert. Thank you for coming. I'm pretty sure everybody will trickle in as they to come on in because yesterday they literally played us. Look at her; she looks so like a baby. This is so sad. But she done put herself in this position, right?
And before we get going, I'm just going to let the media know that
This is crazy.
there's one witness
Hey,
testifying
welcome.
live and
We
two
gonna see if
on
we gonna get this
Zoom,
done today.
and I do not want
I
their
got the alert last night, and
faces
they say we supposed to
broadcast,
have it,
so the camera will need to be turned off or
but I got the
pointed
alert
some
the night
other
before
way,
too.
other than
But
broadcasting their identity. Okay. All right. Very good.
oh, you know the good
All
girls
right.
like bad guys.
Yes. Go ahead, Ms. Doherty.
Judge, I just wanted to briefly make a brief argument before we take witness testimony.
I don't know.
That the defense has filed an amendment
Gone,
for our
young.
to reconsider pretrial detention, and they have added 2 sentences to their factual basis.
What is it?
And before we
Big D
testimony,
whip.
Judge, I just
It's
wanted
all
to
types of
make an
things.
argument based on the sufficiency of their
I mean, to be honest, and she's so young, right?
At all, because it is very
Oh, let me mute up.
that the court, the prior chief judge that ordered pretrial detention in this case, that there is a statute that's directly on point with requirements that are specifically listed within the statute for when a motion for pretrial or an order for pretrial detention can be modified or dissolved. And there are specific requirements for that, which was the basis of my response and motion to strike. And namely, it requires that the defense or the moving party to dissolve or modify the pretrial detention order has to list facts that were not known and existed at the time when the pretrial detention order was in order, and that those facts have a material bearing or relevancy to the reason why the pretrial detention order was put into place. And in this particular case, in section, Judge Sabella ordered that this defendant and put findings on the record that there was a substantial probability that she committed the crime, it was a dangerous crime, and that there were no conditions of release that were adequately in place to safeguard the safety of the community. And the facts that were in his first motion, there were no facts whatsoever that were listed in that motion to meet the requirements of the pretrial detention and release statute. The only reason that was listed was the fact that the morning of trial, due to my medical issue, the state asked for continuance and it was granted. So obviously those facts have no bearing and were not anything that was existing at the time. It wasn't heard or considered by the court who issued the pretrial detention. Subsequent to my response being filed, they filed an amended motion for Arthur hearing and motion to reconsider pretrial detention. And the 2 new sentences that have been added now are 5 and 6. And frankly, again, Judge, these reasons that are listed do not go and are not sufficient to modify a pretrial order of detention that has been in place based on dangerous crime and safety of the community. 5 is just basically since the entry of the pretrial detention order, the parties have had the opportunity to engage in discovery and investigate the case. I don't know how that fact is in existence at the time when we originally had the motion. It's clearly something that has happened afterwards. 6, through the exchange of discovery investigation, the defense has learned that other circuits in the state have gone on record to clarify that ATK is not a gang. And additionally, Ms. Andrews' state of mind has been explored and will be presented. So again, these are stuff that do not meet the requisite requirements of the statute where pretrial detention has been ordered. And so based on that, before we start getting into any sort of witness testimony, this is wholly insufficient. It does not meet the requirements of the statute to modify and order pretrial detention, which in total intent of that statute is to keep people charged with dangerous crimes behind bars if the state has met its burden and proven that a dangerous crime has been committed and that the safety of the community cannot be protected without the pretrial detention of the defendant.
And I think you did make the point in your reply that Judge Sabella didn't even conduct an Arthur hearing.
He didn't, Judge. We had moved for both of those things and argued for both of those. So the Arthur hearing is moot. It's clear that Judge Sabella decided to hold the defendant, and you can hold the defendant based on either of those
Right.
Requirements. And it was very clear on the record and the findings that Judge Sabella ordered pretrial detention pursuant to the pretrial detention and release statute.
And do you concede, Mr. McLima, that at the original pretrial detention hearing that Judge Sabella did not articulate and did not rule on the Arthur factors?
I would agree with that, Judge. That's
Okay.
what's in the transcript.
And do you also agree that pursuant to the pretrial detention statute, in order for there to be a modification, once a court has found that it applies, that they have to be facts not known and the facts would have to be material and have some bearing or relevance to the case? Do you agree with that?
I don't, Judge. So in the state's motion at the bottom of page 3, the state cites to the statute that they're referring to, 907.041
Mm-hmm.
5J. That statute no longer exists. That statute, by research, is from 2023. Statute has since been amended, so that subsection does not exist. The section that reads, a party may motion for pretrial detention order to be reconsidered at any time before defendant's trial. So that no longer exists. In 2024, it just moved to subsection K, and then in 2025, if you look on Lexis, that language doesn't even appear anymore at all.
Okay.
So
What's your response to that, Ms.
Judge,
Doherty?
I specifically cited the statute that was in effect at the time when her pretrial detention hearing was heard. So
Okay.
I had to,
But the legislature has subsequently changed it, correct?
Judge, that is correct.
And so,
In the current statute, that subsection is still in existence. It's just moved to a different letter.
I just,
okay, well, let me take a look. I'll look it up right now. Just make sure we have the most current reading of the statute, and we'll see what it says. But at this point, we can go forward and the defense can call witnesses. All right. So I'm going to deny the state's motion to strike the motion to reconsider pretrial detention. Okay. So who's going to be your first witness?
first witness is Detective Nita.
Okay.
He's on, or should be on Zoom.
All right. Let me look.
And Judge, just to go back, and I'm sorry to belabor the point, but the reason I brought the statute book is it specifically states when that new pretrial detention and release statute goes into effect, each subsection tells when that statute is effective and what the dates are that are encompassed. And the one that I cited to is the one that is in effect. And so the ones that are subsequent to that also say when they go into effect, and that is after the date and time frame.
Of when the original pretrial detention hearing was, or today?
When the original,
I understand,
Okay.
but assuming the language has changed, I'm assuming Mr. McLymont is going to say it's retroactive application. I'm assuming that's what you're going to tell me, right? Or that I can consider, and it's got to be done now pursuant to the current statute, correct?
Yes, that would be my argument.
Okay, so I'll take a look at it and we'll go from there. Okay, yes, Detective, is it Nader? Is present?
Neither, yes, neither. N-E-A-D-E-R.
All right, Detective, good afternoon. Can you hear me?
Yes, ma'am, I can.
Okay, very good. Please raise your right hand. You swear, clerk's going to swear you in.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, you will need to.
All right, good afternoon, Detective. Could you please state your name for the record?
Jacksonville Sheriff's Office,
How long have you worked at the Jacksonville Sheriff's Office?
coming up on 9 years.
You're a detective now, but how long have you been a detective for?
About 5 years.
All right, and what type of detective are you currently?
I'm a detective in the gang unit.
How long have you been in the gang unit as a detective?
3 years.
So from today, going back 3 years.
It'd be 3 years in September, so a couple weeks.
All right. So at the time of the incident, in this case, you had been a detective in the gang unit for how long? Back in June of 2024.
As of when, I'm sorry.
As of June 2024.
2 years, almost 2 years,
Okay. About a year and a half, or maybe a little bit over a year and a half.
roughly.
All right. You in the gang unit, the detectives there, they're assigned to particular gangs in Jacksonville. Is that correct?
Yep.
All right. How many gangs are you assigned to in Jacksonville?
1,
What's the one gang you're assigned to in Jacksonville?
ATK.
All right. And are there any other detectives assigned to ATK in Jacksonville?
No.
All right. So when you're assigned to ATK, but what does that mean? What do you do in relation to ATK and in your investigative capacity?
I investigate the criminal gangs and their members, and I also purge members that they no longer meet Florida state statutes.
And you say you purge members. That means you take members off of a gang list?
Yes, if they no longer meet state statutes, they no longer meet the criteria to become a gang member, they're removed from the system as an ATK gang member.
All right. Is there anybody in JSO that would know more about ATK than you would?
I'm not sure what other people's knowledge is.
Well, is there any detective in your unit that knows more?
I'm going to sustain the objection.
Is there anyone in your unit that spends more time investigating ATK?
Not that I'm aware of.
Do you have daily interactions with ATK in some way, shape, or form?
Say that again?
Do you have daily?
I'm sorry, I couldn't hear you.
Do you have daily interactions with ATK in some way, shape, or form?
Daily?
Yeah, is that?
I'm sorry, did you say daily interactions?
Daily, yes.
It would depend on what you would classify as an interaction.
So either physical interaction, looking at evidence that has something to do with ATK. Is that what you're doing day in and day out, dealing with ATK?
I wouldn't say we have interactions like a face-to-face interaction, but I investigate them day in and day out. Yes.
All right. Do you currently have any confidential informants that are in ATK that you have conversations with?
No.
Have you in the past?
Not for ATK. No.
All right. So how is it that you're able to determine that ATK is a gang?
By Florida state statute.
All right. So when you say by Florida state statute, you're referring to statute 874?
Yes, sir.
And there's some criteria listed in that statute for classifying what a gang is?
That is correct.
All right. So how, in applying that statute to ATK, this group, how have you determined that ATK is a gang?
I would have to, I'm gonna need to pull up the statutes here. You have to give me a second. So Florida state statute states that a criminal gang is a formal, informal, ongoing organization, association, or group that has one of its primary activities is the commission of criminal or delinquent acts, and it consists of 3 or more people that have a common name, sign, color, or symbol, including but not limited to terrorist groups, crime organizations, and hate groups.
All right, so that's the definition in the statute of, I guess, what the legislature defines as a gang, right?
Correct.
And now, how is ATK a gang when you look at that statute and you look at their activities? What do they do that makes them a gang?
Well, they commit criminal acts and they have 3 or more people.
So when you say they commit criminal acts, every person that you know of that's associated or a member of ATK commits criminal acts?
That wasn't, no, that's not what I said.
You said that they
You
create.
asked what is a gang, and that's what a gang is.
Your
So
testing.
the group,
Go ahead.
the group of ATK commits criminal acts, yes.
Okay, so the group as a whole is what you're saying.
I mean, I would be the group ATK.
What I'm just trying to understand is, are you saying that the group ATK commits criminal acts as a whole, or are you talking about specific members?
I'm not, you'd have to rephrase the question. I'm not sure I completely understand what you're asking.
I'm really just asking you to clarify what you're saying when you say that ATK commits criminal acts.
Yeah, I don't know how else to clarify it.
Are you saying that all the members in ATK commit criminal acts?
I'm saying that the group, you asked how the group was documented as the criminal gang.
I know that was the first question. Now the second one is whether the entire group, whether it's your knowledge from your experience, from your investigations, does every member in ATK commit criminal acts? Yes or no? Do you know?
I don't know what the people have done. The members that I have come across, they have committed criminal acts.
Okay. And in your, I guess, in your field, so long as there are some people in ATK who have committed criminal acts, that makes them a gang, since there's at least 3 of them?
Well, they have a common name. They have identifying signs and symbols, and they meet the criteria laid out in the members.
Right, but I mean, basketball teams have the same things, right? Sports teams, music groups.
Sustain the objection. Listen, if you're trying to establish that this is where we're going, that even though this there's been testimony previously that the ATK gang is a gang, if you're going to try and cross-examine or elicit from this witness that it is not in fact a gang, we just need to ask pertinent questions to that. Okay.
So, okay. You said that you read the statute. The statute says that in order for it to be classified as a gang, the primary activity has to be criminal acts, right?
Commission of criminal or delinquent acts, yes.
Right. And are you saying that ATK's primary activity is to commit criminal acts?
That's what would make them a gang.
But I understand that. But are you saying that their primary activity is to commit criminal acts?
I'm not real sure how what you're asking. I explained that they committed criminal acts, which would make them a gang. I don't know what other activities other than criminal, because I'm law enforcement, so I investigate criminal activities.
All right. So
I don't know the other activities that they do.
You know that they make music, right?
I mean, yeah, I guess you could call it music.
When you say you guess you could call it music, what do you mean by that?
I mean, I guess it's a form of music.
All right. So you just don't like the music, but they create music, right?
Okay, listen, Mr.
Right.
McClyment, listen. And I'm looking at the statute here, and I'm looking at the most recent version. And this is the one that was effective February 13th, 2025, correct? That's the most recent version you guys are aware of?
Judge, I'm trying to pull it up on Westlaw right now.
I'm looking at it right now. This is what Westlaw shows to me. This is the most recent version. And it states at 907-041-5K.
That's the pretrial detention. Are you talking about the gang statute or the pretrial?
No, I just want to get us focused on what I'm going to be considering. That's why I'm backtracking on this, okay? So I'm looking at 907-041, the version of the statute that was effective February 13th of 2025, subsection 5K. Quote, a party may motion for a pretrial detention order to be reconsidered at any time before a defendant's trial if the judge finds that information exists that was not known to the party moving for reconsideration at the time of the pretrial detention hearing, and that such information has a material bearing on determining whether there are conditions of release or bail that will reasonably assure the appearance of the defendant as required and the safety of any other person and the community from harm. So that is the standard I will be applying. So all of this stuff, all of this historical stuff about ATK and all candor is not going to move the ball. You need to ask this witness about anything that has occurred since that either wasn't known at the time of that hearing by counsel representing your client, or something that has changed subsequent to. Okay.
So I guess two issues. I think you mentioned that was from February of this year.
Yes.
They make laws after that, the legislature. And
I know, but do you have the more recent version? I'm just
It's
looking at
on Lexis.
Westlaw, and I'm just telling you what Westlaw is showing me, that the most recent version is February 13th of 2025.
I mean, I can show you what I have. I'm not sure what you're looking at, but I can show you what I
I'm
have.
looking at Westlaw. That's what I'm looking at. 907.041. They have this as the most recent version. If I'm wrong,
And Judge, that's what I had made representations to the court as well. Like, I had looked at all versions, and the latest one had just moved it to a different letter.
okay.
But the state cited a whole different subsection, so that wasn't the latest.
I know,
version.
but are you, as an officer of the court, are you telling me that whatever it is you're relying upon as far as it being the most recent version of the pretrial detention order, are you telling me that this language no longer exists? Is that what you're telling me? The
Yeah.
fact, that's what you're
Judge.
telling me.
Yes, so I can show you my computer right now, the LexisNexis.
Well, do you have
You
a
type-
hard, can you print it up?
I didn't print it.
Okay. So at this point, Mr. McLyman, we're not just going to go back and completely reopen all of the testimony from the first hearing. That we're not going to do that. So I need to hear about anything that wasn't known previously, or something has changed as far as a situation that has changed since the hearing that would require me to reconsider Judge Sabella's ruling.
So,
Because that's what you're asking me to do, is
Well-
undo something from a previous judge.
no, well, I filed a motion that has two components to it. An Arthur hearing request and a request to reconsider the pretrial detention order. If I'm asking you to reconsider the pretrial detention order, and if the statute that the state is relying on says what the court is saying, then I would have to go into that framework. For my
Okay.
Arthur hearing, I don't have to show any change in circumstance. I'm traveling under a completely different procedural rule, 3.131, and the first sentence in Article 1, Section 14. So I don't have to show this change in circumstance or anything like that for the Arthur hearing. That's what I asked for.
I know, but
in my
Mr.
motion.
Judge Sabella entered his order. He didn't even address Arthur.
But that's the point. That's why I'm having the Arthur. That's why we're having the Arthur hearing now. She's still entitled to an Arthur hearing.
But I tell you what, let's deal with 907.041 first, and then if need be, we'll get into the Arthur factors. But I'm not going to relitigate all of the facts that were elicited at the pretrial detention hearing. We're not relitigating that. I'm just telling you right now, we're not doing it.
All right. So I guess I can ask my questions. My questions are geared towards both issues, Arthur hearing and pretrial detention. But if I'm only allowed to ask questions as to the pretrial detention, then
Of this witness, let's stick with this witness, okay? And so far, what you've asked him about is his knowledge of the ATK gang. All I really want to hear about from this witness is if something has changed, if there's something about the ATK gang that was not known at the time of the original pretrial detention hearing, I'd like to know about that. if there's anything that's changed since this hearing about the ATK gang, whether in fact it's a gang or not. I would like to hear about that. Other than that, it's irrelevant.
You testified at the pretrial detention hearing for Alicia Andrews last year. Is that correct?
Yes, I believe it was last year.
And during that hearing, did you testify about Isaiah Chance's relationship with youngin' ace Kenyatta Bullard?
I don't recall.
All right. Did you testify about whether youngin' ace paid or has paid for any legal fees for any of ATK's gang members?
Have I testified to that? I don't recall.
At the pretrial detention hearing.
I don't recall. I asked for my transcripts from the pretrial detention, and I didn't receive them, so I don't exactly recall what was said over a year ago.
All right. So are you aware that Isaiah Chance and youngin' ace had a relationship at some point in time? Is that your understanding?
I don't know what you would say by relationship.
I mean,
I would say maybe acquaintances or something like that.
all right. So they knew each other and they communicated with each other?
I'm not sure if they communicated with each other.
So how were they acquaintances in your view?
They would be associates and friends of the same people.
So you're not aware of Isaiah Chance and youngin' ace having any sort of fallout before the incident in this case, before the shooting?
Fallout?
Fallout, like not getting
I'm not
along?
aware. I'm not aware of them two directly. I'm aware of Isaiah Chance and ATK having a fallout. Yes.
Before the shooting in this case?
Before the murder of Charles Jones. Yes.
And what do you know about Isaiah Chance having a fallout with ATK before the shooting in this case?
I'm gonna object again.
Isaiah.
Wait, hold on.
Judge, I'm gonna object again as to relevancy, like we're just going on questions that have nothing to do, that weren't known at the time when this original pretrial detention work was heard.
So the state, the theory of prosecution.
I understand that Alicia Andrews is the girlfriend of Isaiah Chance, who was either a member of or affiliated with ATK, right?
Yes, Judge.
Okay. And so the fact that there had been a fallout between Isaiah Chance and ATK before the shooting, is that new information or is that old information?
Judge, I believe that's old information.
Okay, so it was known at the time of the original pretrial detention hearing.
Yes, Judge, I think that we are still covering similar ground to what he's testified to previously.
You mean the detective who hasn't yet seen the transcript of what he testified to?
Yes, Judge.
So he's guessing.
Yes, Judge.
Okay, so detective, do you recall, I don't know if you recall or not, when you testified at the pretrial detention hearing of Alicia Andrews, do you remember being questioned about the fact that there had been a fallout between Isaiah Chance and the ATK gang before the murder of Charles Jones?
I don't recall the fallout, but I do know when the fallout was. And I don't know if I was questioned about it prior to this or not.
Okay, so when was it?
November 23.
Okay. Okay, Mr. McClamick, go ahead.
Okay. Do you know what the fallout was for?
I don't know direct facts of what it was because I haven't been told. I have my own personal opinions as what the fallout was for.
Okay. I mean, you're the expert for ATK that the state's listed. Could you give us your opinion, whether it be expert or, I guess, your personal opinion?
Yep. It would be after the death of Antonio Tilly, who was close with Isaiah Chance. ATK did not pay their homage and respects of what I would assume Isaiah Chance thought they should have.
Okay. All right, under the pretrial detention standard, I have no further questions.
Okay, Cross.
No, Your Honor.
Okay, may this witness be excused?
Yes, if we're not, I guess I would just make an objection for the record. I had other questions for the Arthur hearing issue. If he's excused, I won't be able to ask those questions. So
Well,
there's the issue.
you can proffer. What else were you going to get into? The whole background of the case?
Well, not the whole background. I have a few sections. This is not the trial, so I'm not going to go over everything with him.
Yeah.
So
I'm going to sustain your objection at this point, and at the end, you can, if you want to create a record, you can by proffering. But okay, thank you. With that understanding, Detective, you are excused. You can leave the Zoom.
Yes, ma'am. Thank you. Have a good
Okay,
weekend.
You too. All right, who's going to be your next witness?
it'll be Ms. Robinson.
Okay, and I believe this is one of our witnesses. I'm going to ask the media to not broadcast her appearance. Ms. Robinson, come forward.
Do you solemnly swear affirm the testimony not to give you the truth, no truth, and nothing but the truth, so help you God?
And for the purposes of this hearing, you can just refer to her as Ms. Robinson, okay?
Thank you. All right, Ms. Robinson, can you tell us how old you are
23,
and where do you currently live?
Jacksonville, Florida.
Do you know who Alicia Andrews is?
Yes,
Who is she to you?
my close friend.
All right, and how long have you and Alicia been friends?
7 years.
When you know what year you met?
Around 2018.
All right, and in 2018, were you in high school?
Yes,
Was Alicia Andrews in high school?
yes,
All right, and would you consider yourselves to be best friends?
yes.
Then and now, or just then, or like what is your relationship with her right now?
Best friend.
All right. So, do you also know who I?
So I have a hot take. AI is not just a buzzword if you use Monday CRM.
I'm so glad you said that. So for me, email composition.
Maybe around 2022.
Okay. And when Alicia and Isaiah Chance got into a relationship, were you around their relationship? Were you in the vicinity? Or did you see them hang out at all? Did you see them interact?
No.
All right. At what point did you begin to see them interact?
What do you mean? Interact?
Like talk to each other on the phone or in person or anything like that? Go out on dates?
I never really seen that.
All right. Have you ever met Isaiah Chance?
No.
Have you ever spoken to him?
Yes.
All right. On what form or what mediums have you spoken to him on?
Twitter.
Any text messages, anything like that?
Yes.
Did Isaiah Chance and Alicia Andrews have anything, any physical altercations between the two of them in the beginning of their relationship?
What's the relevance of this?
Again, the state's theory of prosecution here, the motive for why Alicia Andrews is even involved in any of this stuff is because she pretty much just loves Isaiah Chance so much that she would go and help him plot and complete a murder.
Okay.
That's the relationship that the state is putting forth. That's the only motive that they have in this case as to why Alicia Andrews is involved.
Okay, for the purposes of this hearing, I'll go ahead and let this witness testify as to this, okay? But again, keep in mind, it is binding case law. There is no defense of duress in the state of Florida, but I'll allow you for the purpose of defense of duress in the state of Florida, but I'll allow you for the purposes of this hearing to go ahead.
I understand, Judge, that we're not arguing any duress defense or asking for any instruction on that. So were there any physical altercations between Alicia and Chance when they first started dating?
Not around the first time they started dating, maybe further into the relationship.
When you say further into the relationship, what do you mean?
Maybe a year later, the abuse started to occur.
All right, in 2023?
Yes.
And how did you learn of any abuse between Alicia and Isaiah Chance?
She would send me,
Objection, hearsay.
Hearsay is allowed at a pretrial detention hearing and in our hearing.
Yes.
Hold on, you got
Hold on. Yeah, that's fine. Go ahead.
yes, so during the abuse, she would send me pictures via Instagram and text message of her being choked, of her eye, of him punching her, and bruises.
Okay. That's pictures. That's not any words, right?
Yes, correct
All right.
pictures.
But did you also get text messages from her about these bruises and things,
Yes.
injuries?
Yes.
All right. Can you tell me what that document is I just handed to you?
The document that you did hand to me was Alicia stating that
Hold on.
I-
Don't tell me what's said yet. Just tell me what the document is. What is it?
basically of Isaiah choking her and me stating that he needs to stop putting his hands on her.
So you're telling me what's in it, but tell me what is that you're looking at?
Oh, an image of me and Alicia messages and Isaiah.
Okay. Is it a screenshot?
Yes, it's a screenshot.
All right. And where does the screenshot come from?
Text message and Twitter
From whose phone?
from mine.
And is that screenshot has been altered in any way?
No.
Is it an accurate depiction of the screenshot that's in your phone?
Yes.
And is there? I'm asking the court to admit this into evidence.
Well, I'm listening to her testimony, and so you want now to admit the screenshot? Do you have it something on paper?
It's on paper. I handed her the
Okay.
document.
Any objection just for the purposes of this hearing?
No objection, Judge.
Okay, that's fine. Go ahead and admit it. Defense one,
Yes.
have you marked it?
Not yet.
It'll be defense one.
All right. So on the left of that document, can you tell me? Or can you just read it to the court?
Yes, I can.
Well, first, tell me who's the conversation between on the left.
Between me and Alicia.
Go ahead.
So the message between me and Alicia is she stated that Isaiah did choke her. She stated that, bruh, excuse my language, bruh, this bitch almost killed me. And I stated, who? She said, Zay. And I replied, what did he do? She said, I couldn't breathe. I said, he choked you? She said, yes, he covered my mouth. I couldn't breathe. 10 more seconds, I would have been dead. All my blood was rushing to my face. And I replied, he is weird. What is wrong with him? Is he being insecure? She said, I sent it to you. It's red as fuck. He's trying to kiss me and hug me. No, something is really wrong with you. And I replied, see, you got to stab him.
All right. So do you remember when that was, that exchange between you and Alicia?
February 10th, 2024.
I'm sorry, what was that date?
February 10th, 2024.
And do you know if that was like the first time that you heard anything, or was it like down the road, like in relation to the other times that they got into any physical altercations? What is this?
Around the time frame that was kind of in the beginning.
This was the beginning?
Yes.
All right. And did you have any other conversations with Alicia about this incident?
About this incident, no.
Can you tell me what happened after this incident? Did you tell her to call the police or anything like that?
No, I did not.
All right. Why not?
Because that wasn't my place.
All right. And now on the right, could you read that text message and tell the court who it's from or who it's between?
The whole thing?
Yes.
Is this a composite exhibit that you're gonna do? Is this a different date?
So
Is this a different text exchange from February 10th of 2024? Is it the same day? What is it?
the way that it's a composite, the way that it's printed out, Judge, there's two side by side, and I guess it should have been printed on the other page. So it's two different dates, Judge. The one
Okay,
that
so just for the record, we're now moving on to a new date.
we are.
What date is that? What's the new date?
I'm gonna tell her to give the date.
Okay, thank you.
So on the right, could you tell the court who that message is between?
Me and Isaiah.
All right, Isaiah Chance.
Yes.
And do you remember the date on that?
Around March 4th, 2024.
Okay. Could you read to the court what that message says?
He stated that we both were wrong, I understand, but she pulled the first trigger. She threw the first punch, hypothetically speaking. Yes, physically it's gonna hurt. It'll fuck you up, but come on now. Emotionally, that hurt. Intentionally wise, my scars and cuts and bruises run deep and won't never go away. Open forever. I can't even look at her the same. I told her that and be telling her that I wish it was something or somehow she can make it up. I see she's apologetic and hurt, but I'm hurt, but that shit can't fix that. But what time and few scratches and bruises. Man, that shit gonna go away. Physically, I'ma still be forever stuck with it. Mentally and emotionally, not never forgetting. So at the end of the day, who is really losing? Me.
All right, and did you respond to him?
Yes, I did. I stated, still say that's not right. If you love somebody, you don't put your hands on her. He stated, girl, what? I said, y'all got history and that is not how love is showed. He stated, you don't get it and you never is because you're a female.
All right, is that the end of those?
Yes.
All right. I'm sorry, let me ask you to explain. When it says here, she threw the first punch hypothetically. When you got this message from Isaiah Chance, was your understanding that Alicia?
It's speculation, Judge.
Sustained.
Well, let me ask you this. Do you know what Isaiah Chance meant when he said she threw the first punch
Objection.
hypothetically?
It's speculation.
Well, that hypothetically means she's speculating.
No,
So I'm
the
gonna,
message says the word hypothetically in it. So I'm not telling her to give me hypothetically.
well, I don't need her to guess what Isaiah Chance meant.
I'm
So
not asking her to guess. I asked her if she knows, yes or no. If she doesn't know, then
well,
it's
do you
speculation.
know?
No.
Do you know if Alicia to hit Isaiah Chance?
No.
Do you know if Alicia to be a violent person?
No.
And do you know if Alicia is affiliated with any gangs?
No.
No, she's not.
She's not.
I have no further questions at this point.
Okay, Cross.
Just briefly, Your Honor. Ms. Robinson, you don't know or have not personally seen any sort of abuse between Alicia Andrews and Isaiah Chance, is that correct?
That is correct.
You've not personally witnessed any incident of the two of them interacting where either one of them have hit one another, is that correct?
That is correct.
Your sole knowledge based on the abuse that is claimed in this case is based on communication from Alicia Andrews herself, is that correct?
That is correct.
And each of these incidents that you have spoken about, the last one to your knowledge occurred in March of 2024, is that correct?
That is correct.
And Alicia Andrews, despite whatever history she has with Isaiah Chance, she continued to date and see and live with him well after that time period, isn't that correct?
That is correct.
And you're aware that she traveled with the defendant to Tampa the weekend of this homicide, is that correct?
That is correct.
And not once during your relationship, and you said you are a close childhood friend with Miss Andrews, is that correct?
That is correct.
And you have never once called law enforcement and reported any sort of claim or abuse that Isaiah Chance has done to your friend, your good friend Alicia Andrews, is that correct?
That is correct.
It has never gotten to the point where you yourself thought her life was in imminent danger, is that correct?
Yes, but that wasn't my place to call the police on.
Well, certainly if you had thought that she was going to be killed, you would pick up a phone for your good friend, wouldn't you, ma'am?
Yes, I would.
You would call, you know her parents, don't you?
Yes, I do.
And certainly if you thought she was in serious danger or jeopardy, you yourself would call her mother and let her mother know. Isn't that true, ma'am?
Yes.
And you have not done that once in this entire relationship between Alicia Andrews and the defendant, co-defendant Isaiah Chance. Isn't that true, ma'am?
That is true.
All right, I have nothing further, Judge.
Okay, redirect.
Yes. Regardless of what you did in response to what Isaiah Chance did to Alicia Andrews, do you know that Alicia Andrews was abused by Isaiah Chance?
Yes.
All right. And then the state mentioned that Alicia was still living with Isaiah Chance. Alicia did not live with Isaiah Chance at any point in time.
No, she did not.
All right, where did she live?
With her parents.
No further questions.
Okay, may this witness be excused?
Yes.
Yes, Your Honor.
Okay, thank you, ma'am. You are free to go. All right, and your next witness?
Zoom.
Okay, and do you know, I don't see a name on here that corresponds.
I can ask Mr. Andrews. Ms.
Hold
Mills.
on, I haven't let them in, but because you didn't want their face, so again, I'm just gonna ask that once I let these people in on Zoom, that any of their faces not be shown, and then if you tell me who's who, and that person will remain in the Zoom, the others will be put in the waiting room. So podium does have its, okay, but I don't think it's got sound.
Just went off. Just off.
There's a phone number that's trying to connect from the 904 zip code. I don't know, is that Jacksonville? There's an iPhone and another phone number.
Maybe I could try to ask Mr. Andrews or Ms. Mills, if either of you are on the Zoom platform, can you unmute your microphone?
Okay, if you all can hear me, I do need either Ms. Mills or Mr. Andrews to please unmute themselves and at least acknowledge you can hear me or hear counsel. Not hearing anything. Wait. Okay, you know what? Oh my God. No more Zooms. No more Zooms in this case. I am horrified. 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 Disgusting.
Judge, can I take a 2-minute recess?
Yes.
I just don't understand why they don't have a tech in the building in all courtrooms that is immediately available. Please explain. Yeah, that's why we wait. Well, at least we getting some testimony in today in regards to why they think that she should be released, even though I don't think that she will be. Um, don't sound like the judge is having it in regards to the motions that her attorneys are trying to put up. At all. She's just the wrong people, wrong time, and came into her life. She done had a baby and everything. I'm almost sure she done had a baby. You say it was just a disruptor on Zoom. Well, I hope they get it together so we can continue on with, since they have had us waiting a whole day, right? But I wish they had the court people, right? The tech support, even if it is just a disruptor, get that mess together so we can continue on. I guess because her family, if they are going to be testifying, it sounds like they may be. They are in Duval County. So they're not down here in Tampa because remember, they don't stay there. Yeah, I'm sure there are ways that they can figure out how to get some secure links and stuff out there. Oh, excuse me. Something where we do Zoom all the time. When we had that thing, that health scare, right? That was really, really bad. It taught us a new way of living. I don't know, but don't she look so innocent? I guess people can look innocent and be something else. I don't know. I don't know, y'all. I think that she might be able to. I think maybe she can convince a jury. I don't know that her lawyer gonna have to get better, but
I did. My proposal is that we don't allow
I would
everyone
think
in, we
as a
just
juror,
change their
I'd probably
names
be
on
sitting
Zoom
over
to the
there
correct
like-
No, I'm not opening up that Zoom again, so.
Depending
they
on what
can appear
evidence coming in.
telephonically if the state doesn't object.
I know they ruled out the DV, but
So,
Is there a number they
that
can
was,
call?
I think that was
Yes.
a real big thing that she wanted to, of course she wanted that to come
unfortunately, I
in.
don't know it.
Oh, sorry, I'm talking.
But if you give me their number and let them know that I will be calling them, then, actually, you give me their number and then, because it's loud.
All right.
Okay. Okay, and is this
Miss
Mr. or Miss?
Miss Mills.
Miss Mills, all right. They just changed our phone system, so I don't exactly know how to use it now. Let me see here. me check my emails. They just changed out our phone system and they did something different as far as making calls. Let me see what. Yeah. That's it? It's a long distance. I tried that. I just tried a direct call. Didn't work. Let me try one more thing. Let me go look up the number in my JA's office. We so rarely use this. I'll be right back. Ms. McClymonds, I think this is the number, so come get this, and if, are you communicating with them via text?
Yes.
Then text them that number at the bottom, and have them try that, and we'll see if it comes through. Good afternoon, this is Judge Cisco. Is this Miss Mills?
Yes, ma'am. I'm sorry about that. I don't know what happened. I'm sorry.
It's all right. Listen, we're going to proceed forward. So wherever you are, please raise your right hand. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, very good. Mr. McClymonds, you may proceed.
All right. Good afternoon, Miss Mills.
You may have to, I don't know if she can hear you or not, but this, it's
Can you
very
hear me from
Good
animated.
afternoon.
Can you hear me?
I can hear. Good afternoon.
All right.
Okay, go ahead.
If you can't hear me at any point, just let me know, please. All right. Miss Mills, can you please tell us where you currently live? Not your address. Yeah. Okay. And how do you know Alicia Andrews?
She's my daughter.
All right. And did Miss Andrews, your daughter, did she live with you at any point in time in her life?
Can you repeat the question again?
Yeah. Did
I'm sorry, Judge, can we turn it down maybe just a little?
Yeah, I'm gonna need you to step up here to do the questioning, because I've got to turn this volume down. So just stand up here next to the phone, Mr. McClimate, and make life simpler. Okay, go ahead.
All right. Can you hear me?
Yes, I can hear you.
All right. So the Miss Andrews, Alicia Andrews, how long did she live with you?
21 years. 21 years.
Her whole life?
My whole life. Yes.
At any point in time, did Miss Andrews live with anyone else besides you?
No, sir.
And who all lives in the home?
Alicia, my other daughter, my grandson, and my husband.
Your other daughter is how old?
She'll be 25 on Sunday. But she called her 24, but she'll be 25.
Okay. And then your husband, what does he do for work?
He drives tugboat.
He drives what?
Tugboat.
Tugboat.
Like TUG?
Like seamen, like working seamen.
Can you spell semen?
Drive boat.
Can you spell semen for us?
Seaman, S-E-A-M-A-N, seaman.
Okay,
Like working seaman, like a
got it. How long has he been doing that for?
I'm not sure, over 5 years, I'm not sure.
And do you all own a home?
Yes,
Can you tell us, do you know who Isaiah Chance is?
yes,
All right, who is Isaiah Chance?
Alicia friend.
All right, and do you know when Alicia met Isaiah Chance?
I believe around 2022, I believe.
And what was your understanding of the relationship that Alicia had with Isaiah Chance?
They were just friends.
Okay, and would she leave the house to go to his house at any point in time?
She left with him once when I first met him.
All right.
But I don't know him, personally. I just know that I met him the first time.
When you say you don't know him personally, you didn't have any relationship with him?
No, sir.
And Alicia, was she in a sort of relationship with him, more than just a friendship?
Yes.
Okay. And did you at any point in time learn about any issues that they had between each other?
Yes.
All right. What issues did they have?
I learned about the domestic violence.
What did you learn about it?
When she came home and he hit her in the eye.
Do you know when that happened?
It was I know it was like a week or two before all of this stuff transpired.
Is that the only time that you're aware of any physical altercation between the two of them?
Yes.
All right. Did you hear of any others since that time period?
No, only when she told us about that. He hit her in her eye.
All right. And when she was hit in her eye, what did you do about it?
I asked Alicia, did she want to go to the police station and put in the report, but she was afraid.
What was she afraid of?
She was afraid of Isaiah Chance.
All right. Were you aware of any any alleged gang affiliation with Isaiah Chance?
No, sir. I'm just learning about it as all this stuff happening now. That's how we all learning about it. I never knew.
And if Alicia were released, let me ask you this before I get to that. Alicia, did she graduate school?
Yes, she did. Yes, sir.
How far did she get in school?
She graduated to the 12th grade.
And did Alicia have any jobs after she graduated?
Yes, she had several part-time jobs.
Could you explain what jobs Alicia Andrews had?
She worked at Amazon, Firehouse. She was a substitute teacher, was a last employee, but she worked with special needs kids. And she also had
One second, Ms. Mills. 1 second. Give me a second. Hold on. The court reporter is having trouble hearing you. At times, just kind of slow down so she can hear you better because it's a little bit of static.
The last I heard was Amazon and I think Chick-fil-A. Then you said she might have been a substitute teacher where?
Yes, she worked at Amazon, Firehouse, and she was a substitute teacher where she worked with different kids like special needs. And she also had a suite where she rented a suite where she did lashes and facials and she does hair.
Okay. So in Alicia's, I guess, spare time, is she working majority of the time?
Yes, she was doing hair and different facials and lashes. She went to school for esthetician. She got an esthetician license. So she was doing that on the side.
Do you know of her to be involved in any gang activity?
No, sir. My daughter's not in the game now. No, sir.
And if she were released or granted some form of release, where would she go to live?
She would be home with me and my spouse and my daughter and my grand.
Okay. When you say your grands, are you referring to Alicia Andrews' daughter?
My grandson and my granddaughter.
Is the granddaughter you're referring to, is that Alicia's child?
Yes.
All right. And do you work currently?
No, sir. Right now, I'm on the field right now.
And if Alicia were released, I guess, to your custody, would you be able to monitor her?
Yes, sir.
All right. And would there ever be a time when she's at the house, I guess, by herself?
No, sir.
And why not?
Because I have my daughter here and I also have my husband here.
All right. And
And I
say the last part again. You broke up.
my daughter and my husband and my grand.
Okay. 1 second. No further questions.
Okay, State, do you have any questions of this witness?
I do not, Judge.
Okay, thank you, ma'am. I'm gonna go ahead and hang up now, all right?
Thank you.
Okay, all right, bye-bye.
Bless you.
All right, you wanna have your next witness call in as well?
While we're waiting, Judge, I was able to get the statute printed up, so I can provide a copy to the state and to the court.
And what was the effective date?
Give me a second.
The effective date was February 13th, Your Honor.
I know, but that's what I'm looking at online right now. So I don't understand where the, let me see what you've got, because I'm looking at it right now online on Westlaw. 907.041, pretrial detention and release, effective February 13th, 2025. And I just read you all the pertinent statute. And the version you have says current through the 2025 regular session. When did the regular session end?
I don't know the answer to that question, Judge. This is the statute that I pulled in Lexis. It just came up.
I don't know who this is. I'm scared to even answer.
That's
That's Mr. Torres. Why don't we go ahead and call him? I'll answer the phone. Hi, Mr. Torres?
Yes, ma'am.
Okay, very good. Wherever you are, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and I'm going to turn up the volume for him because he's a little bit, see how this goes. Okay, you may proceed.
Mr. Andrews, can you hear me?
Yes, I can hear you quite fine.
All right. So could you please tell us your relationship to Alicia Andrews?
I am Alicia's father.
All right. And could you tell me if at any point in time you lived in the same home with Alicia?
Yes, all of her life. She was living with me and her mother.
Are you and Miss Mills, are you two together?
No, we're not.
And when,
We've been co-parents.
okay, so how long have you been co-parenting?
I would think that Alicia was 2 years old.
So you interacted regularly with Alicia?
Yes, of course.
All right. And like, how often would you see her?
Probably every other weekend or every weekend and some days during the week.
Okay. And what about holidays?
Yes, of course on holidays. Every holiday. We never miss a holiday or birthday.
And do you own a home?
Yes.
And who lives in your home?
Me, my wife, and my bonus child.
You said in what?
My bonus child, stepdaughter.
Okay. All right. And where would Alicia be going if she was granted some form of relief before the trial?
She would be here with me or with her mother. One of the two.
Okay. Do you know who Isaiah Chance is?
I don't know him. I have never physically met him. We were supposed to meet, probably one holiday, but he never showed up. But I never got the opportunity to meet him personally.
Okay. Do you know if that was for any particular reason?
To me, after all this has transpired, I think it may be, the way I carry myself, and I'm not that type of guy. My lifestyle is not structured that way. So I believe he may have maybe felt as if I would not allow him to see her going forward.
When you say you're not,
That's the only thing I can possibly say. I can't really say what it would be because I never met him.
okay. Now, you have a job.
Yes.
What do you do for work?
I'm a refrigeration container refrigeration mechanic.
And how long have you had that job for?
27 years.
All right. So you have a stable job, and you're able to manage Alicia if she's out? All right, you're able to provide support?
Yes, definitely.
Are you able to keep her just away from individuals, certain individuals?
Of course. Now, if this transpired, we would definitely, much less her mother, would definitely make sure that doesn't happen. Or anyone. So for the most part, she will be at home. She won't go anywhere.
Did Alicia ever like hide things from you? And let me be more specific. Did Alicia hide her relationship with Isaiah Chance from you?
I can't say, I would say so because I never got a chance to meet him. You know, I know more about him based on what's going on now than I ever knew about.
And you also became aware of this domestic violence?
Yes.
When did you become aware of it?
One particular day, her mother called, and when I arrived, I learned that she had a black eye, and I asked her what was going on, that other, and if I'm not mistaken, I asked her what happened, and I assured her that, you know, no one should be putting their hands on. I never put my hands on my daughter, so I wouldn't allow anyone to put their hands on my daughter. So, you know, one thing led to another. We never really got into the conversation. You know, I think she was more or less hurt, much scared. And, you know, for the most part, she stayed away. Then all of a sudden, you know, this happened.
Do you know Alicia to be a violent person?
No, she's not a violent person.
Is she dangerous?
No, she's not dangerous. She wouldn't hurt a fly.
All right, and well, I guess give me 1 second. All right, you said that Alicia is not dangerous and she's not violent. Are you saying that just because she's your daughter?
No, I mean, in the view that, you know, other people may see, or the view, if that's not the view for me. You know, Alicia's never been in any trouble. Alicia's never harmed anyone. She's never been in trouble. She's not a violent person. You know, she's my sweet little girl. And no, I won't be just saying that because that's my daughter. I have other children. And the way I raised my children, I didn't raise them this way. To be violent. Or to be considered some kind of member of a gang.
I have no further questions.
Okay, any questions?
No, Judge.
Okay. All right, thank you so much, Mr. Torres, and I'm gonna hang up the phone now. Your testimony is concluded.
Thank you very much.
Okay. Okay, any additional witnesses?
Just Detective Ramos.
Okay.
I solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help me God.
Right this way, sir.
Okay, you may proceed.
All right, Detective Ramos, you are the lead detective in this case from Tampa Police Department, is that correct?
Yes, sir.
All right, and I guess there's no other police officer or detective in Tampa Police Department that knows more about this case than you.
That would be correct.
And you've been on this case from the beginning,
Correct.
and you're still the lead detective now.
Correct.
All right, you had a role in issuing the warrants in this case?
Yes.
All right, and you testified at the pretrial detention hearing?
Correct.
All right, in the pretrial detention hearing, do you remember testifying about Alicia Andrews sort of following Julio Foolio, Charles Jones around Tampa, Florida?
Of course.
All right. When you testified at the hearing that Alicia Andrews was following Charles Jones around, can you say when from your, I guess, investigation, when it was that Alicia began to follow Julio Foolio, Charles Jones.
So we had multiple pieces of evidence to include GPS, cell site data. So the device of Alicia Andrews shows that device traveling from Jacksonville in the early afternoon of Saturday, the 22nd, traveling from Jacksonville to Tampa, Florida, where obviously Mr. Charles Jones was expected to perform. As far as when they began the act of driving to where he was physically located, it happened approximately between 1:30 and 2:30 in the morning of the 23rd, when Mr. Charles Jones was expected to be at Teaser's Lounge.
Okay, so Mr. Jones, he is at Teaser's at what time?
Between 2:30 and 3 in the morning on the 23rd.
And Teaser's is the first place that Mr. Jones goes to that night, public place.
Public place, correct.
All right, and then after Teaser's, Mr. Jones goes to Truth 18, correct?
Correct.
All right, and then after that, he goes to a hotel.
Correct.
All right. Did Alicia Andrews, from your investigation, did she follow Charles Jones to Teaser's, the first location?
Yes.
How do you know that?
Because she's on video and she identified herself from that video.
When I say did Alicia Andrews follow Charles Jones, like, was she behind his vehicle, driving behind him to get to Teaser's?
I'm not going to get into the specific of what the definition of following is. Mr. Jones arrived on video. And then shortly after, Alicia Andrews arrives on video. She is seen getting out of the car, walking up to get within eyesight of the front door where Mr. Jones was waiting to go in. After Mr. Jones goes into the club, she then retreats back to her vehicle and drives away in stages nearby based off of the cell phone data. So by following, I mean Mr. Jones arrives and then Alicia arrives shortly after. And on video, you can see Alicia positions herself in a position where she can see Mr. Jones.
All right. So I kind of want to take this step by step. And the first thing you're saying is that
Objection, Your Honor. I am going to object.
I'm going to sustain the objection. This was all part of the initial hearing. I've read the transcript. So again, and we'll talk about what you gave me and what I see online regarding 907.041, specifically, and what you gave me from Lexis, and I cannot explain this. But Westlaw has something different from Lexis regarding what 907.041 says, both of those showing being effective February 13th of 2025. I would note in the version you gave me, there is no provision for even reconsidering a pretrial detention motion. It's not even in there in what you gave me. The only place that I see it is in the Westlaw version. And again, as I stated, the only way that the court can reconsider it is if there was information that was known at the time and that the information has a material bearing. So we're not going to revisit all of the testimony taken by Detective Ramos at the original pretrial detention hearing. I've read the transcript. I am familiar with it. And so we need to focus on what evidence was not known at the time.
all right. So I would like an opportunity to at least hear the legal objection from the state and then get a chance to respond to it.
They did just object. And they said,
Well, I didn't get the legal basis. It just said objection and the court sustained it. I didn't get an opportunity to
okay, go ahead, state the legal basis.
Judge, we'd object as to relevancy. As we have previously stated, this is already, all of those questions have already been litigated in the original pretrial detention motion.
Sustained. Okay.
and I didn't get a chance to respond to it. But again, for the record, the state is arguing a standard for reconsideration of a pretrial detention motion. I filed a motion for an Arthur hearing under 3.131.
Right, but if
No.
we're going to first address under the standard of the pretrial detention statute, because if I find that the motion for reconsideration should be denied, then the Arthur factors become moot. And again, Judge Sabella didn't even address it at the original hearing. So you've made your objection noted for the record, but.
And I want to also add this. If the court could revert to the pretrial detention standard when someone files an Arthur hearing, the Arthur hearing standard and the Arthur hearing, the constitutional provision for it the statutory provision for it would be meaningless. It would have no effect because the state would file a pretrial detention motion, they'd have a hearing on it, and the court would do what it's doing now, which is to say, hey, let's deal with the pretrial detention standard. Let's not deal with the Arthur hearing standard, which is also what happened, apparently what happened at the first hearing in this case.
So again, under either standard, okay, we're not revisiting what already occurred at a pretrial detention hearing. Judge Sabella has already ruled, and you're asking me to undo what Judge Sabella did. And I'm telling you that we're not going to get into any of the facts that were developed at the pretrial detention hearing. This is a motion for reconsideration. This is not a reopening of all of the testimony. We're just not doing it.
Again, I'm not asking the court.
Okay, Mr. McLymont, we're not going to see eye to eye. I've ruled, so you need to elicit from this detective any facts that were not developed or testified to at the pretrial detention hearing, whether they be pursuant to the pretrial detention statute or Arthur. That's what we're doing.
All right, and this fact that I'm trying to get to is a fact that was not elicited during the hearing. And if I could proffer, I guess I'll proffer the issue here. The issue is that Detective Ramos testified at the pretrial detention hearing and just now that Alicia Andrews arrived at Teasers after Charles Jones got there. His report say different, the video evidence says different, and that is the point that I'm trying to make right now. That would be new evidence that the court did not consider the first time around.
Okay, go ahead with that issue.
Detective Ramos, you wrote a report in this case, right?
Yes.
And in the report, you list, at a certain point in the report, you list the times that you see different vehicles and individuals on video, correct?
Correct.
All right. And do you remember writing in your report when the silver Chevy Cruze arrived at Teasers?
The silver Chevy Cruze arrives before Charles Jones does, correct.
Okay.
But Alicia Andrews is not visible in that silver Cruze that first. It drives through the parking lot and then it leaves. I don't see Alicia Andrews visible on camera until after Charles Jones arrives. So if your question is if the vehicle arrived before, yes, it did.
Well, her cell phone data shows that she was there in that vehicle at the time when the Chevy Cruze was on camera, right?
Correct. I believe her to have been in the vehicle before Mr. Jones arrives.
So
Sure.
So why are we suggesting that she was not in the vehicle?
I'm not suggesting that. I believe her to be in the vehicle.
So she was at Teasers before Charles Jones got there.
That is my belief,
All
yes.
right, so there's no way that Alicia Andrews followed Charles Jones to Teasers, correct?
Again, Mr. Jones was expected to be there. It was publicized on his social media, so she would have had knowledge that he's going to be there. So we have established through the evidence that the sole purpose of her being there is to get to Mr. Jones.
You established that through evidence.
Through the investigation, yes.
You had-
There was no other reason. In her statement, she claimed that she was there to possibly patronize the club. And she stated that she talked to the bouncer and inquired about the price to come in. And that's disproven via the evidence. So based off of all of the video evidence and the ultimate investigation, it is our belief that her sole reason for being at Teasers was to track Mr. Jones' movements.
All right, so that's your belief.
Yes, of course.
Now, Miss Andrews, after they leave Teasers, they go to another location, correct?
Correct,
Right.
yes.
They go to a club called Players Club, correct?
The Truth 18.
No. Did you look at the call detail records in this case?
Okay. Yes, I did.
All right. And you're telling me that Alicia Andrews left Teasers and went directly to Truth 18?
No,
So-
I'm not saying that.
So where did Alicia Andrews go after she left?
Somewhere off of Hillsborough for a few minutes, and then she returned to Truth 18 when Mr. Jones was exiting, and then it went back to somewhere off of Hillsborough, and then she made her way to Truth 18 after. Yes, she was loitering in the area of Hillsborough Avenue. At least her device was in between Teasers when Mr. Jones went into Teasers and came out of Teasers, and in between when Mr. Jones came out of Teasers and got to Truth 18 and came out of Truth 18.
So just to simplify it, after Miss Andrews leaves Teasers nightclub, she goes to somewhere on Hillsborough.
Correct.
And that area where she's at on Hillsborough is right next to the Players Club.
I'm not familiar with whether there's a club there or not.
So did you get any video footage from the Players Club?
Again, I have no, I'm aware of what you're referencing, and the cell site data is consistent with that, that yes, her vehicle and her device made its way to Hillsborough, somewhere in between. But there's two vehicles working in concert, in this. So, and I don't know what she was doing on Hillsborough, and that wasn't, I'm not sure if she went to a Players Club on Hillsborough.
All right. So that you don't know where Alicia Andrews went after she left Teasers, you don't know what she was doing in that moment in time.
No.
And Charles Jones leaves Teasers to go straight to Truth 18. Is that accurate?
Correct.
And when Charles Jones is at Teasers, or when he goes to Teasers, is Alicia Andrews following behind him?
When Charles Jones pulls out the Black Impala, which was Sean Gaithwright's Black Impala, as Charles Jones is coming out of the club, he gets into his car. You can see on video the Black Impala arrive and position itself directly in front. There's also some communications in the phone from Sean Gaithwright's phone to Alicia Andrews' phone. And then Alicia Andrews' device starts making its way back up towards Teasers as Mr. Jones is leaving. But there's limited angles in the video, so I do not see Alicia Andrews' vehicle arrive on video prior to Mr. Jones leaving.
All right. Do you remember what the question was that I asked?
If Mr. Jones is being followed.
Well, the question was, did Alicia Andrews follow Charles Jones from Teasers nightclub to Truth 18, behind him in the vehicle?
No.
All right. Was she even at Teasers nightclub when Charles Jones left Teasers nightclub?
She was working her way back to Teasers nightclub, so no.
She was not there.
Correct.
All right. And by the time Alicia, did Alicia actually go back to Teasers at any point?
The device appears that it made it back to Teasers, yes.
Did it make it back, or did it drive by Teasers?
I can't tell that based off of the data from the device.
All right. And the reasons why, I guess, like you testified in the past, that the reasons why Alicia Andrews is involved in this case is for a few things. One is because you're saying she tried to book an Airbnb. That's
Correct.
The first reason.
Correct.
All right. And is that the first indication that Alicia Andrews had anything to do with this murder plot?
Yes, I believe that message was sent Friday, the 21st, so it would have been the first act implicating her in the plot to murder Mr. Jones, yes.
All right. And Alicia Andrews, from your investigation, she sends a message to someone on Instagram asking them for information about an Airbnb.
In Tampa, correct.
All right. And at that point in time, you don't know if Alicia had any knowledge about any murder plot.
No.
All right. There was no message that showed Alicia Andrews saying, "Hey, we're going to Tampa booking an Airbnb."
I've never testified to such. Yeah, no, there's
No?
none.
Okay.
Yeah.
All right. And you don't have any evidence that she knew of any murder plot when she tried to book this Airbnb or when she inquired about the Airbnb, right?
Of course not.
Okay. When you say "of course" now, what do you mean by that?
Well, what I mean is the message is sent on the 21st. Mr. Jones doesn't get killed till the 23rd. I have no way of proving at that time what is in her head. I know now, after Mr. Jones was killed, that the purpose of the Airbnb was to house a group of individuals that came from Jacksonville, whose primary mission was to kill Mr. Jones. But I can't know on the 21st that she knew that was going to happen.
Got you. When Alicia Andrews left Jacksonville to go to Tampa, do you have any evidence that says she knew that she was traveling or that the group was traveling down to Tampa to kill anyone?
No.
All right. When they got to Tampa, do you have any evidence that shows that Alicia Andrews knew that these other individuals were going to kill Charles Jones?
The first indication that there's some possible consciousness of guilt is in the arrival at the Airbnb. There's a Ring camera that covers the front door that captures any movement near the front door. And I stated this in my report. You know, it is our belief, based off of analyzing that footage and speaking to the owner, that there was no way that the four gentlemen who came with her would have been able to get into the Airbnb unit without activating that camera through the front door. The only person seen going into the Airbnb on the arrival is Alicia Andrews. And therefore, it is our belief, based off of analyzing that there's two ways in, a back door that would have been locked. We believe Alicia Andrews went into the Airbnb and unlocked the back door to allow the four gentlemen to come in through the back, which, you know, I would argue is you know, a consciousness of guilt, or if she knows that these four men need to conceal themselves from this camera.
All right. So whether the back door was locked or unlocked, that's pure speculation.
Again, objection, Your Honor, we're going into an area that definitely was covered during the pre-trial.
I agree.
Well,
Sustained.
I asked, so this is what happens. I'm asking a question. Detective Ramos is going on a very long tangent from the questions I asked, and he's bringing up a lot of things that are.
Well, then why don't you cut him off? Like, if he's going on a tangent, then cut him off and say that, thank you, you've answered my question, let's move along, because this was all testified to. All of this was testified to at the original pretrial detention hearing. These are not new facts. These are all known facts.
So, I mean, they're alleged facts. And
I understand they're alleged facts, but they're all known alleged facts. This is nothing new. This is nothing
So
new.
it is, if I get an opportunity to cross him, you would find new information. And if the court wants me to cut him off while he's answering questions, and if I have that leeway, then I'll take it. So,
well, what you can't do is, if he answers the question and he goes off on a narrative, you then can't bootstrap that and come back and say, well, now, Judge, I get to get into everything that happened before because Detective Ramos just kept answering. So, Detective Ramos, please just try and answer the question asked, okay? And I think that will
Yes,
help
Your Honor.
everybody.
So you're saying the first indication, I guess, that Alicia Andrews has any consciousness of guilt is when she opens the Airbnb door in Tampa.
Yes.
All right. And you have a video of her opening this Airbnb door.
Entering through the Airbnb door.
Entering
Through the front door.
All right. And in this video, when Alicia Andrews approaches the front door, you see someone let her in from the inside, correct?
No.
You don't. How did she open the door?
She rings the doorbell, and I spoke to the owner. He has a way to unlock the door remotely and speak to her through the intercom on the camera.
So are you saying the owner opened the door for her?
That is my belief, yes.
When you say it's your belief, did the owner tell you that?
Yes, I spoke to him. He said he let the first, he didn't say that he let specifically Alicia Andrews in. He said he let the renter in through the door by unlocking it remotely. That's what he told me.
All right. And that's your sworn testimony?
Yes.
What's the owner's name?
I don't recall.
How many times did you speak to him?
Once.
And when Alicia Andrews goes to the front door, does she have, who's she talking to on the phone?
I don't know.
She's not talking to Isaiah Chance when you want to let her in?
I don't know that she was talking to anyone on the phone. I hear audio, and it sounds like she's talking to somebody possibly through the intercom of the ring. I don't know who she's talking to.
So you don't know who she's talking to?
Correct.
And you don't hear the owner saying that he's going to let her in?
No.
A brief moment.
Yes.
had an opportunity to have a full conversation with an individual named Robert Howard after the pretrial detention hearing. Is that correct?
Correct.
All right. And Robert Howard is one of Charles Jones's, or was Charles Jones's friend, correct?
Correct.
Close friend?
That's what I understood.
Robert Howard was driving the vehicle that Charles Jones was in the night he was murdered, right?
At some point during the night.
All right. And his Robert Howard's, I guess, nickname is Kenny Caps.
Correct.
And Robert Howard, was he a documented member of any gang?
I don't know.
You don't know?
My understanding is it's 6 block, but I haven't seen that documentation myself.
Okay. So your understanding is that Robert Howard was a member of 6 Block.
Correct.
And 6 Block, according to, I guess, the Jacksonville detectives, is at war with ATK.
And 1200 and others.
Okay, but ATK is the gang, one of the gangs that 6 Block is at war with.
One of them, yes.
All right. And is your understanding that Isaiah Chance is a part of ATK?
It is my understanding that Isaiah Chance was originally a part of ATK. There was some kind of falling out, and then he started associating with 1200.
All right. And 1200 is also a rival gang of 6 Block.
Correct.
So in either way that you put it with Isaiah Chance, he's involved with people who are rivals to ATK.
Correct.
But Isaiah Chance had a relationship with Robert Howard in 6 Block, right?
Yes, he did.
And that relationship was friendly.
Yes, according to Mr. Howard, they had conversations.
All right. Hours-long conversations
That's what he said.
on FaceTime
Correct.
with Alicia Andrews' phone, right?
I can't recall that part.
You can't recall? Do you remember Robert Howard telling you that his girlfriend put Alicia Andrews' phone number in Cash App and then questioned him about why he's talking to a woman named Alicia Andrews?
Vaguely, yes.
All right. And do you remember Robert Howard saying that he doesn't know an Alicia Andrews? And him learning that that was actually Chance using her phone?
I can't recall that fact.
When's the last time you talked to Robert Howard?
A few weeks ago,
And he's a state witness?
yes.
And was he prepared to testify to these things before trial?
Yes.
And at the pretrial detention hearing, did you have this knowledge? Were you aware that Robert Howard and Isaiah Chance were cordial and talking to each other on FaceTime with Alicia Andrews' phone?
No, I was not aware of that.
And Robert Howard and Isaiah Chance were actually cordial with each other, talking to each other with Alicia's phone leading up to the night of the murder.
But it's my understanding now that they were cordial, but they were not on the same side of the gang rivalry.
Right, that's the whole point.
Yeah.
They're on 2 separate sides, but 2 of them are friends.
I wouldn't say that they're friends. They're cordial. I would agree with.
So they're talking on the phone, FaceTime for hours.
Sure.
I think that friends do.
Sure.
And Alicia Andrews is obviously aware that Isaiah Chance is talking to Robert Howard.
If I'm guessing if he's using her phone, sure. Yeah.
Does Robert Howard have any evidence that Alicia Andrews knew that Julio Foolio, Charles Jones, was going to die on June 23rd,
No.
2024? Does Robert Howard have any evidence that Alicia Andrews was involved in the planning of murder of Charles Jones?
No.
And does Robert Howard have any evidence, did you get any evidence from him as to whether Alicia Andrews even knew that Charles Jones was going to die on June 23rd?
No.
Did you talk to Sean Gathwright's grandmother before or after the pretrial detention hearing?
I've never talked to Sean Gaither's grandmother. That was a different detective, but that was done during the investigation before the pretrial detention hearing.
Okay. since the pretrial detention hearing, you've had an opportunity to run ballistics in this case,
Correct.
and you've had an opportunity to collect and analyze guns, ammunition, casings, all of those sorts of things, correct?
Correct.
Objection, Your Honor, because we're now clearly going into facts that did not exist at the time of the original pretrial detention hearing.
I thought that was everything the court wanted me to get into, were things
Well,
that
go ahead.
didn't exist.
Overruled.
All right, you had an opportunity since the pretrial detention hearing to analyze different pieces of physical evidence, right?
Yes.
All right, that includes guns, ammunition, casings, and of that sort, right?
Correct.
Things that were involved in the planning and the murder in this case, right?
Correct.
All right. None of the evidence, physical evidence, contains Alicia Andrews' DNA. Right?
Correct.
None of the physical evidence in this case contains Alicia's fingerprints, right?
Correct.
And you can't say whether Alicia even saw a gun on the night of June 23rd or June 22nd leading up into the 23rd.
No, I can't.
No further questions.
Okay, Ross?
Just briefly, Judge. Detective, the defense attorney asked you about the vehicles and the silver Chevy Cruze being at the location at Teasers prior to the victim, Charles Jones. Is that correct?
Correct.
And you testified that there was communication between Alicia Andrews' phone as well as a phone that was in the black Chevy Impala, Sean Gaffright's phone. Is that correct?
Correct.
Was the, based on that phone, same phone evidence, now we're talking of Sean Gaffright, were there indications that the black Chevy Impala had been earlier, before the victim had arrived, Charles Jones, to either Teasers or to Truth 18?
Yes, approximately at 10 p.m., Sean Gaithwright's device can be seen going by Teasers.
And how many times or how long the street in front of Teasers was that black Chevy Impala and Sean Gaffright seen earlier, 10 o'clock, before the victim even went to that appearance in front of that club?
It loitered in the area for approximately 30 minutes to an hour and drove by Teasers multiple times.
Okay, and these were known locations where the victim, Charles Jones, was going to be, is that correct?
Correct.
And then going back to the silver Chevy Cruze that the defendant was in, the only time where she actually got out of the vehicle is after the victim, Charles Jones, and his entourage had arrived. Is that correct?
That is correct.
Okay, I have nothing further, Judge.
Okay, redirect.
So Alicia Andrews gets out of the vehicle after Charles Jones arrives, which you just said on
Correct.
Redirect or cross. So when Alicia Andrews is in the back of Teasers in that vehicle, can she see Charles Jones arriving to Teasers?
When she's parked in the back?
Parked in the back, and they're back in next to the gate. She can't see Charles Jones arriving to the Teasers nightclub.
From that position, no.
All right. So when you make the point or the argument that she does not get out of the vehicle until after Charles Jones arrives, she doesn't even know that he's there.
Mr. Jones arrived and parked and loitered in front of the club for a while. So her vehicle arrives after Mr. Jones' vehicle has arrived and he's gotten out of the vehicle and he's loitering. So she would have been able to see him before she parked. From when she's back there, she can't see him, but then they walk towards the front.
You testified earlier that the silver Cruze was there before Charles Jones got there, right?
That it circled the parking lot before.
On the video, Alicia Andrews arrives, or let's say this, the silver Chevy Cruze arrives before Charles Jones, right?
Okay, I don't want to go on a tangent, but I want to make it very clear, okay?
I'm gonna take.
The Silver Cruise.
No, there's different times
Sure.
that she arrived, the Chevy Cruze
Yes,
arrived,
different
correct?
times. The
There's
first
a first
time-
time and a second time.
Correct. Yes.
So again, we're repeating yourself, but again, walk us through what occurred the first and second time.
All right. So
Go ahead, Detective Ramos, just tell us.
I think he answered the first question.
No, actually, he didn't, because I feel like the record's getting a little bit muddied between the first and the second time the Chevy Cruze arrived. So I think it would be helpful if Detective Ramos just walked it through one more time regarding the Chevy Cruze at Teasers. Go ahead.
Yes, Your Honor. So the Silver Cruise is seen on camera arriving into the parking lot. It is not seen parking a first appearance before Mr. Jones arrives. The Silver Cruise then goes off camera. Then Mr. Jones arrives. Then the Silver Cruise is seen coming back on camera a second time. And that's when the Silver Cruise parks and Alicia Andrews gets out.
All right. So I want to go back to the first time the Silver Cruise is on the camera. You see in the camera footage that there's absolutely nowhere to park at Teasers when the first time that the car comes in.
I can't recall if there was any open parking spots. I'd have to review the video.
All right. You see, yeah. I'm going to put this video here.
And for the record, what are you showing the witness?
I'm showing the witness a video of the camera angle that points to the back of Teasers.
The screen's locked.
And the purpose of, I guess, showing you this video is so you can see the moment when the cruise arrives. You can just let us know when you see it.
It just came on the view.
Now pause it. So could you tell the court what time on the, and we'll get into what the difference in the time discrepancies and whatnot. Could you tell the court what time you see on the video?
The timestamp is 2:10:28, and the video is approximately 7 minutes and 23 seconds slow. So the correct time would have been closer to 2:18.
Okay. All right. And that's when the silver Chevy Cruise first arrives.
This first visible on camera, correct?
Right. And from that camera angle that you see there, the parking lot is full.
Correct.
There's not a space to park.
That's what it appears, yes.
There's actually even a line inside like somewhat of a line inside the parking lot area.
There appears to be several vehicles that are not parked, that are running, yes.
All right. So after this, the silver Chevy Cruise goes off camera.
Correct.
You don't know where it goes exactly.
No,
Does it leave the area?
no,
All right. And then it comes back on camera at another point in time.
correct.
Do you know at what time it comes back on camera?
I can't recall the exact timestamp.
When it comes back on the camera, does it pass by the back of the club or the front of the club?
I believe it enters the same way it entered the first time.
All
Which would have been directly to the west of the front door.
Okay. All right. And when they finally come back, the silver Cruise comes back, there's a parking lot, a spot.
Correct,
All right. And they park in that parking spot.
correct.
It's like, is it the only parking spot in that lot?
We'd have to forward to that spot because I can't recall if there was more open spots.
I'm showing you the same video. I just moved the time up. I'll let you read the time into the record.
Sure.
All right. What time do you see on the video now?
Timestamp's 2:17:01, so the correct time would have been approximately 2:24:30.
Do you see the silver Chevy Cruise pulling back into Teaser?
Correct.
When it pulls back in, how many parking spots are available in the parking lot?
In the general area where it's at, 2, it appears,
All right. Where are those parking spots at?
along the back fence line on the north side of the parking lot.
So there's no parking spots up front.
There's no parking spots anywhere else in the vision of this view, like in the view of this camera.
So the only spots you see are towards the back.
Correct.
And they go to the back and they park.
They back in, yes.
All right. And then once they park, they get out of the vehicle.
Yes.
Now, the reason why they got out of the vehicle, I guess you're suggesting earlier that it was only because Julio Foolio Charles Jones had arrived at the location. Is that the suggestion you were making?
Yes.
Could they have gotten out of the vehicle when they first arrived and there was nowhere to park?
If in that specific view, or
The first time the cruise arrives, there was nowhere to park. Would it be your expectation for them to get out of the vehicle at that point in time?
they actually waited a little bit before they got out, so they didn't get immediate out. It wasn't like immediately park and get out. They
That's a different question.
Yeah.
So
I
the
don't-
question I'm asking is the first time that the cruise arrives
Uh-huh.
and there's nowhere to park.
Sure.
Do you expect them at that time to get out of the vehicle?
I'd be speculating. I don't.
There's no reason for somebody to get out of the vehicle if the parking lot is full and there's nowhere to park.
Oh, okay. I see what you're saying. You're saying the first time, since there was nowhere to park, could they have possibly gotten out while the vehicle was in motion? No. But yes. So yeah, I agree.
So when they do find a parking spot,
Mm.
it's then that they get out of the vehicle.
According to the video of the camera, yes.
I don't have any other questions.
Okay, very good. So may this witness be excused?
Yes.
Okay, thank you, Detective. You are free to go.
Have a good
Any
weekend,
additional witnesses, Mr. McClymond? Any additional witnesses?
No, Judge.
Oh, okay. Okay, state any witnesses.
No, Your Honor.
Okay, so I'm gonna, again, I don't know why Lexis and Westlaw have a different 907.041 version. I really don't. But in looking at it specifically for our purposes, the pertinent subsection is subsection 5, which deals with the pretrial detention statute. And when comparing the one that's on Westlaw that I'm looking at, the one that the state apparently has, and the one you gave me, Mr. McClymond, I would notice subsections G, K, L, M, and N are completely different in the two versions, and I can't explain it. I would note, Mr. McClymond, in the version you gave me, there is no authorization for a motion for reconsideration. It's not contained in here at all. There's no right to it. So I don't know that you would want me to use the Lexis version because there is no language authorizing a motion for reconsideration. So based upon everything in front of me, I'm going to go with what I have. And again, 907.041 pretrial detention and release subsection K states as follows. A party may motion for a pretrial detention order to be reconsidered at any time before a defendant's trial if the judge finds that information exists that was not known to the party moving for reconsideration at the time of the pretrial detention hearing, and that such information has a material bearing on determining whether there are conditions of release or bail that will reasonably assure the appearance of the defendant as required and the safety of any other person and the community from harm. And this is what Judge Sabella had to say at the pretrial detention hearing, the initial one. He didn't specifically reference 907.041, but he did articulate the language, particularly from, I think it's subsection 5D, and he stated as follows. This is a circumstantial case, but I believe that there is strong circumstantial evidence, at least under a principal theory and perhaps a conspiracy theory. I am finding that there is a substantial probability that all three defendants, and Ms. Andrews was one of the defendants at that pretrial detention hearing, that all three defendants committed the dangerous crimes that they are charged with. I find that the factual circumstances of these crimes indicate a disregard for the Tampa community. I further find that there are no conditions of release available that are sufficient to protect the community from further risk of physical harm. So I will grant the state's motion for pretrial detention as to each of the three defendants. So, Mr. McClymond, let's start with you. First of all, what is the information existing that was not known to the moving party at the time of the pretrial detention hearing? And what is how does it have a material bearing on the determination that was made by Judge Sabella?
Yes, so at the pretrial detention hearing, the judge has to make pretty much two findings. First is that whether there's a substantial probability that Alicia Andrews committed the offense. And then the second is whether there's a laundry list of other items in the statute that if one of these other items applies, then the pretrial detention statute applies and the court may hold, or at least the new statute says that the court shall hold an individual in detention. So that second part that Judge Sabella mentioned is that there were no conditions that would keep the community safe from Ms. Andrews.
I know you're telling me I understand what 5D says. That's the pretrial detention. That's what gave him the authorization to initially hold Ms. Andrews in pretrial detention without bond. I'm asking you under subsection K to please identify for the record, what are the facts or information that was not known to the moving party at the time of the pretrial detention hearing, and how does that information have a material bearing on determining whether there are conditions of release or bail that will reasonably assure the appearance of the defendant as required? Tell me what the new or what the unknown facts were at the time of the pretrial detention hearing.
Right, so there's several things that Judge Sabella did not consider during that hearing. One would be
No. Listen, I'm not revisiting the legality of Judge Sabella's order. I'm not an appellate judge. I'm asking you what was not known at the time of the hearing. Not that he overlooked it. If it's already in the record, I'm assuming he heard it and it factored in his decision. I'm asking you what was not known at the time of the hearing.
Judge, I'm trying to answer the question.
Okay.
This is the third time I'm trying to answer the question.
Okay.
The things that he did not know, or the things that weren't presented to him, the parties didn't know. One, the parents testified here today. That didn't happen at the other hearing. The information that they provided today was not privy to the court previously. In addition to that, the testimony about Robert Howard, and I'm going to go over why this is relevant and the court should consider it. I want to list out the things that are new first and then go back over it. The testimony about Robert Howard that was elicited today was testimony that the officer did not know at the time. The lead detective, the court did not know. Right? And I don't know if the state knew at the time either. In addition to that, there's the domestic violence information, which goes to the state of mind and whether Alicia Andrews had the motive to sit around and support her boyfriend's mission to go and kill an individual. So those three things, in addition to, those three things are new. I guess new information that the court didn't consider at that hearing. Not that he overlooked it, he just didn't consider it. And then the other thing I forgot to mention is the fourth thing, which is that since the pretrial detention hearing, there's been an opportunity for the state and the Tampa Police Department to go over, analyze, and look at all the ballistics in this case, and determine whether Alicia Andrews even had any of the guns in her possession at any point in time, whether she saw any guns, whether her DNA or prints were on any of these guns. And so these four main, points I want to harp on for the pretrial detention issue. The Arthur hearing is separate and aside. I'll make some arguments about that after, but I think it's relevant to the court, and I think it's pertinent here for the court to consider these four different things because they all weigh in favor of Alicia Andrews. And why do they weigh in favor of Alicia Andrews? Because they all show that she had no motive, that she had no knowledge of what was going on, and that she was a person that was just really tagging along. And again, Robert Howard, I'll start from Robert Howard. He is a member, according to the state, of 6 Block, this rival gang. Alicia only knows that Robert Howard is talking to her boyfriend, who's supposed to be in a rival gang, through her phone on FaceTime, several times for hours on end. So the state paints a picture. The theory of prosecution is that, hey, why would Alicia Andrews drive from Jacksonville to Tampa if she knew that her boyfriend was at odds with 6 Block and with the members of 6 Block? Why would she do that? Alicia Andrews did not know that her boyfriend was at odds with 6 Block. I mean, from the evidence, it appears that her boyfriend and members of 6 Block were friends. That her boyfriend was using her phone to FaceTime Charles Jones's best friend at the time of his murder, leading up to his murder, and in weeks and months before that. So from Alicia Andrews' standpoint, she has no idea that the Murphy brothers are even coming to Tampa. She has no idea that the Murphy brothers have their own issue with Charles Jones. She's coming down from Jacksonville to Tampa with this understanding that there is no problem between her boyfriend and 6 Block or Charles Jones or Robert Howard, his best friend. In addition to that, the whole idea behind the state's case is that Alicia Andrews is, her and Chance, they're together, they're thick and thin. She doesn't have any actual problems with 6 Block. She doesn't have any gang affiliations, any gang membership. She's not involved in any of the gang activity, the back and forth. No one from her family or her friends have died at the hands of a 6 Block member. So the only motive that the state has put forth for Alicia Andrews is that she's so in love with Isaiah Chance that she would do anything he asked her to do, that she would follow behind him, do this, do that, and she would even go as far as helping him to plot a murder. The evidence from the hearing that was not considered or known to the court before is that Alicia Andrews was being abused by her boyfriend at the time, abused by Isaiah Chance, and that this relationship that the state paints, this fairy tale relationship that they paint, is not accurate. And no matter how much the state wants to say that the friends didn't call the police, they didn't get involved, these things happened to Alicia Andrews. There's proof of it. We didn't make up text messages from the past. We didn't make up photographs, and we didn't pull a witness in here to perjure herself. These things actually happened, and they were happening right up until the incident of this case. In addition to that, her parents testified to that domestic violence. They testified that they learned of it just shortly before this incident happened. They didn't really know Isaiah Chance because Alicia Andrews kept things from them about her relationship. And they testified, which is important, to talk about the environment that Alicia Andrews will be going back into if she's released. She has 2 families, a mother, a stepfather, a biological father, and a stepmother. 2 homes in Jacksonville, separate and apart from anything to do with Isaiah Chance. She does not live with him. She never lived with him. It's important for the court to know that if we're releasing someone, we're not releasing them into a similar or same situation that they were in prior to the incident in this case, that she's going into a situation where she's got support, she's got people that are going to be watching her, looking out for her, someone in the house with her the entire time, and as the court knows, we're asking for a form of house arrest in this case. So someone would be at the home with her pretty much 24/7, a supervisory figure. And in addition, the last part is the physical evidence in this case. And physical evidence is, in most cases, the most important thing. If Alicia Andrews' fingerprints or DNA were on a casing, were on a magazine, were on a bullet, were on a gun, anything, a mask that these individuals use, the brass catchers, any of that, if her DNA or fingerprints were on any of these items, you could say maybe that she knew that guns were involved, that she knew that someone was going to get killed. There's not a single piece of evidence that shows that Alicia Andrews touched or saw a gun during that night or at any point in time, because her DNA or fingerprints could have been left on any of those items at any point in time leading up to the murder or even after the murder. And there is nothing that shows that Alicia Andrews' DNA or prints are on any of these things. So those are the things that I guess the court is allowing me to argue at this hearing. Of course, again, the defense's position is that we filed a motion for an Arthur hearing as well, and that we should have been and should be allowed to get into much more than what we were allowed to get into today. And that the standard in an Arthur hearing is that the state has to prove by proof evident presumption great that Alicia Andrews is guilty of the crime that she's charged with in order for the court to hold her. We're arguing that the state, even with the information that was elicited today, I mean, limited information, it's makes it better for the defense because the state isn't able to prove proof evident presumption great that Alicia Andrews is guilty of these charges. So we're arguing that the state hasn't proved that she's entitled to a bond in that instance, and that had we been allowed to let me just profit for the court. Had we been allowed to question the detectives more about their investigation in this case, we would have learned that ATK is really not a gang at all. It's a group of kids who make music. That there are state witnesses who testify on behalf of on behalf of the state to testify to say that ATK is not a gang. They're state witnesses that have turned into informants for the state. Testify that ATK is not a gang. Several of them. Detective Nieder testified that he has never even had. He's the gang detective for JSO. He's never even had an informant talking to him about ATK. Everything he knows, with Crawford, most of what he knows comes from off of YouTube videos. The state has turned over in discovery evidence of charts, organizational charts for these different gangs, ATK in particular. And in these charts, you see a hierarchy, you see a level of some sort of these different members and their names and their associations with these gangs. The chart that the state turned over, the state used during the first pretrial detention hearing, is a chart that is taken from off of a YouTube video. And Detective Nieder uses these videos to come up with his conclusions. And we would have learned through Detective Nieder that Alicia Andrews is not like any of these other people who are involved in ATK, for the simple fact that when other people in ATK have criminal cases, their fees, their legal fees are paid. Alicia Andrews doesn't have any connection to these individuals. She doesn't know them. The only one that she knows is affiliated with ATK at all is her previous boyfriend, Isaiah Chance. And he's in jail. And he's not, I don't think he's getting out right now, right? That's another big issue in this case, is that any influence that Alicia Andrews had from her previous boyfriend is gone. The fact that he's in jail. She would be out, she would be at home with her parents, monitored by them, and she would have an opportunity to prepare for her trial that is coming up and not be in jail preparing for the trial, because it's very difficult to prepare for a trial while someone is in jail. To talk to the person, to communicate with them, to show them videos, to go back and forth. These things are difficult when it's time to prepare for trial. And so I'm asking the court to take into consideration the things that I mentioned that are different now from the first pretrial detention hearing, the things that the court has an opportunity to hear and weigh now that the court did not have an opportunity to hear and weigh at the original pretrial detention hearing, and reverse the pretrial detention order in this case. But I'm also asking the court on a separate procedural vehicle to issue, in order that the state does not prove by proof evident presumption rate the burden that they have in this case, that Alicia Andrews is guilty of the crime that she's charged with.
Okay, Sturdy, response?
Yes, Your Honor, I'll be brief. All of the facts that defense has gone over with, they do not have a material bearing to the decisions that were made by Judge Sabella. I do want to speak briefly about the ballistics evidence, the fact that she is not in a gang. Those have been facts that have been known all along. We never expected to see her on any shell casings holding a gun. We have never alleged that she was ever the shooter in this case. It is clear based on the video evidence, which is evidence of the crime itself, which there is a significant amount of video evidence, because where this crime took place were at public venues, at 2 clubs, and that at a hotel, all of which had video surveillance. So that the evidence here is actually what happened in this case. And she is seen on all of it. And she admits to being at all of those 3 locations in her interview with law enforcement. And it is very clear by the timing and the different camera angles exactly what the circumstantial evidence and nature of this case is. It has always been a circumstantial case, but it is overwhelming based on the timing of this case and the phone evidence of the coordinated tracking of Charles Jones in Tampa by 2 vehicles, and the tracker vehicle, which always comes before the black Chevy Impala that housed 3 gunmen that were heavily armed, very sophisticated crime brought here from Jacksonville to Tampa. And the tracking of these vehicles is done through license plate readers that lead from Jacksonville to Tampa, starting the day before, where they are traveling in tandem, where both the Chevy Cruze and the black Impala both show up similarly through this route. So you have 2 vehicles traveling together. So it has always been the state's position, even at the pretrial detention very early on in this case, that she was never the shooter, that she was never in a gang, that the only connection that she has to the gang is through her boyfriend, Isaiah Chance. So all of those facts were known. So the fact about ballistics, the facts about the parents testifying, all of that does not have any sort of bearing on why the facts that were presented at the pretrial detention hearing and why Judge Sabella made the decision that he did. He watched and saw all of those video surveillance and saw the timing of when one vehicle came, when the victim came, when the victim was seen, when the victim left, and then when those vehicles left. And he saw the coordination at each of those locations, as well as the cell phone information, which is her cell phone, by the way. And based on that and the type of crime that was committed, this was a crime where this victim was gunned down and was targeted, and where 3 heavily armed assailants that were prepared to take out this victim, 2 of which had assault rifles. The other one had a 9mm that was completely unloaded with 31 casings that were found left in Tampa, and a Tesla video, as well as the video surveillance at the hotel, which showed that the victim was targeted. And all of that is a dangerous crime that she participated in as a principal. We have never suggested that she had a gun in her hand at any time, but that she clearly was tracking the victim along with her boyfriend based on what was seen on that video. And so based on that, the judge found that this crime, the egregious nature of this crime, was a dangerous crime, and it was the way that it was instituted definitely indicated a disregard to the safety of the community. There was additional testimony that there were guests staying at that hotel, that bullets went into those guest rooms. There were 2 guests, in fact, where families had been staying.
I'm familiar with the facts, Ms. Doherty. We need to just stick to, listen, Mr. McClymonds raised 4 points that he said were not known. One is the ballistics. However, there was no ballistic evidence, I don't believe, that was presented. So that's nothing. Ballistics did not play a part in Judge Sabella's decision, because there was no ballistic testing done at that time, and there was no evidence introduced as to that. The information regarding Ms. Andrews being a victim of domestic violence, that is new. And then Robert Howard, what's your position on if that has any material bearing?
Judge, it doesn't. Robert Howard was an eyewitness and was with the victim, and he was not very cooperative or did not give a full statement initially. We have since taken a sworn statement, and yes, he has tried to say that 6 Block or ATK, they're not gangs, but he is a member, and he's actually in federal custody for a manslaughter, not in federal custody, but he has previously been sentenced to a manslaughter for another death as a result of this gang war. So whenever you ask one of these members if ATK is a gang or 6 Block is a gang, they will say no, that it is not a gang, but that is not what determines what a gang is in Florida or how it is documented per statute. So it doesn't have any material bearing on why the judge made the determination that there was a need to protect the community, and that holding her that there were no reasonable means to or no reasonable conditions released to adequately protect the community. It has no relevance or bearing on that whatsoever. The domestic violence judge, obviously, we're not contesting that that happened. Domestic violence should be prosecuted wherever and whenever it happens. She has never reported it. There was nothing ever that we could find to corroborate or not corroborate it until they listed witnesses. But again, under the state of Florida and the law, this is not a case where she is murdering or trying to defend herself against her attacker. Duress is not a consideration and does not excuse her participation in killing or murdering another individual, not anything having to do with her abuse. It just is not relevant.
Okay.
And was there any other fact?
No, that's fine. So, okay, so based upon the testimony and the governing statute as I interpret it, first of all, with regards to the parents, I know they testified that they could basically monitor and provide a home for Miss Andrews, but the situation remains, she has no ties to Tampa. And that was articulated at the pretrial detention hearing, and that remains a fact today. She may have someplace she can live in Jacksonville, but she doesn't have a place here in Tampa. With regards to, so their contention that they could monitor her around the clock in Jacksonville does not have material bearing to me as far as Judge Sabella's original decision. The testimony of Robert Howard and the lack of ballistics or fingerprint or DNA, as well as the domestic violence information, again, I find those do not have a material bearing, and therefore I'm going to deny the defendant's motion for reconsideration for release pursuant to 907.041, the pretrial detention statute. Now, if you would like to make your Arthur argument, please do.
Well, on the pretrial detention issue, so you mentioned that the fact that Alicia has family in Jacksonville does not, I guess, quell the court's concerns about Judge Sabella's order from the pretrial detention hearing.
Well, it's just, it's a one of a number of factors that don't. It's
You mentioned it, so I want to just.
That's
correct
fine.
this issue.
Go ahead.
Judge Sabella, in his order, did not say that he made any factual findings that Ms. Andrews was a flight risk. What his order says is that I find that the factual circumstances of these crimes indicate a disregard for the Tampa community. So if she's at home in Jacksonville, then his factual findings of her being in Jacksonville would be fine. And then he further says, I further find that there are no conditions of release available that are sufficient to protect the community from risk of physical harm, not to prevent her from, or to keep her from coming back to court. And there's a distinction there, a clear distinction, because he could have made a factual finding that he says, or that he believes that there's no condition that could have her come back to court. And he didn't make that finding. And so when I discuss, or when we bring up the evidence about the parents being in Jacksonville, that doesn't negate anything that, or it doesn't harm Alicia Andrews in relation to what Judge Sabella issued during the ruling he issued during his pretrial detention.
again, I find it does not have a material bearing on Judge Sabella's initial ruling. So do you want to make your argument for the record with regards to the Arthur factors?
Well, I made the argument, the Arthur factors, Judge.
Okay, so you rely upon the record for that. Okay, very good. Okay, so we are concluded, and Ms. Andrews will remain held in custody pursuant to the pretrial detention statute. And is there any reason we need to get together before jury selection you all can think of?
I mean, I might file a motion for like a more specific exhibit list.
Okay. Whatever you do, please just do it sooner as opposed to later. So if you need to get back before me, it's fine. I'm heading into a death penalty case starting September 24th. So my calendar is going to get very tight quickly. So if we.
Judge, I have that ready, so that's something that I may make some amendments to that, but I certainly can give him those things.
Okay, very good. Okay, we're concluded. Thank you.
Court adjourned.
Wow. So we all kind of figured that she was not going to be able to get bail, right? The trial is in October. We will be watching it. It was supposed to happen in August on the 18th, but they decided not to. Something happened with the head prosecutor in this case, and they didn't have the trial. With that being said, just so everybody knows, I think the judge was kind of like, she was aggressive with him, but only because what he was trying to argue or present had nothing like he wasn't following the rules, right? So in order for it to come up for a reconsideration for the actual bond, so it's kind of like she had to overrule the pretrial judge's decision. And what she's saying is, what changed? What didn't the pretrial judge know? And so he, the attorney, unfortunately, like he was coming in like he was just about to argue this, and she was just trying to explain to him, like, I'm not an appeal lawyer. I'm not an appeal judge. Let me correct myself. So I think she was just kind of, but these things like this, if she knew that this was going to be his argument, I guess, like, why couldn't she tell him before she put this on her calendar or before we decided to do this? Y'all seen the motion? And we read over the motion yesterday, which kind of like, and they do have a lot of evidence on her. She was in her interrogation video like, I was here. And so the judge was probably like a little irritated, like, look, dude, I keep telling you, it has to be this 907 point whatever she was saying. I'll get the code at some point in time. But she keeps telling him it got to be this, and he arguing something that he can't argue in front of her, because she like, well, you have to prove that there was something that that has came out that the prior judge was not aware of. And that was something that he just did not have together. And so I think that's why she was getting a little, and she allowed him to go ahead and, okay, you can have mom, dad, sister, brother, detective, everybody, the gang expert. You can have them all march up here to the stand. It appears that her mind was made up before the hearing even went through, because he didn't meet that first thing that she needed him to meet. What is different? And that's why when the state got up there, they like, hey, all of this was known. She was on video. We have never said that she was going to be on the shell cases. We have never said this. We already knew all of this stuff. The judge already knew all of this stuff prior to us even getting here. So they had all this information when they made the decision earlier to detain her. Did you guys watch Pro Se Daryl Brooks? Think of it in that way. The judge had to explain things to him. I think this judge was sort of in the same boat a couple times, right? Like kind of teaching them to go, like going through law school in the middle of the trial. But if anything, he gonna learn today. He gonna learn during this trial, because she is definitely the judge on the trial, and that's okay. I like when the judge runs their courtroom. Have your stuff together. Don't come making arguments. And if you do need training and stuff like that, hopefully that guy that was sitting there will assist him. The only way you can learn, right, is to fall and hit your head maybe a couple times. Maybe not once. No, we don't like to do it that way. But that's why his bill was so long. And although he's advocating for his client, he's advocating for her, and he was just throwing stuff at the wall. That's why he was up there so long-winded, because he like, I'm just gonna throw anything out here that may possibly stick. Yeah, right. Oh, look, yeah. I mean, that's a mistake that he won't make again, right? You hope, because that's gonna stick in his head. And besides, they probably not gonna let him live on the internet. Yeah, because she gonna be teaching him through trial. I know that Nosy, you said that you seen in another chat that he been practicing since 2019. That's not really like a long time for an attorney, right? And he's a public defender. Because I didn't think that detective helped him at all. It's definitely going to be great for us to watch, and we will be up in that courtroom, Ola. Don't you think we won't? We will be nosy. We will be nosy. We will be up in that courtroom because at the end of the day, somebody lost their life, right? And you know, regardless of what she knew or what she didn't know, she knew after the fact. And if anybody knows, when they went and arrested her and her boo thing, Isaiah Chance were together. They got arrested together. Like they literally, she came out of the house. We showed the video yesterday. They look like she didn't have no shoes on, no nothing. He had on his slides, looking like they were just in there getting it down. Okay. Nobody else was at the house but them, and they looked like they had been rolling around. So, I mean, she been in here all this time, right? The trial is in October. That's another reason why I'm glad the judge denied. Like, why take that chance? We so close to trial. Why would I let her out now when we so close to this trial? Yes, we had a delay because we had a medical emergency with one of the prosecutors, but why would I let her out now and take that chance that she may run or she may not make it to one of her court dates? And then you gonna come up here and tell me on top of that, she don't have no ties here because she came 8 hours away or whatever amount of time it takes to get from Jacksonville up to Tampa to unalive somebody. Like the means that they went through to do this is really like egregious. Like can't stop, won't stop. Like they nobody thought on it the whatever amount of time of the drive that this is not a good idea. You telling me we had 5 people that was involved in this and nobody thought, hey, I don't want to be involved? But it's something with them gang wars down there in Florida because it still got something to do with that ATK, CFK, KFC. I don't know. They got all these different names, 600, 500, 98th Street, claiming all this stuff that don't nobody own. All right. So, yeah, so it becomes a whole entire problem. And it has something to do with these who owns the street and who don't own the street, who made a song, who's smoking on who. I know they have no respect, no value for life. And it's so crazy to me how it is almost like it irritates my soul at different points in times when we are reviewing these trials. Like, who are you to decide when somebody live and when somebody should be unalive? Like the nerve of you. Like if you would just stop and think back to yourself, what if somebody thought that about you? But no. And then they doing all this arguing over stuff that don't nobody own. You think about the stuff that they had going on in Chicago, like they all stayed blocks apart from each other, right? Blocks apart from each other. You know, one street 80, I don't even know the street names, but it was just street names, right? We from 86 and you from 90th. We 4 streets apart. We got to always walk past each other and we going to beef with each other and don't nobody own the street. They don't even own the land that they fighting on in these names. But I don't know. It's a lot. They don't think And that's why people are taking like these lyrics to these songs and stuff really, really like where they're trying to bring it into the court systems, because it's not even so much that they doing all this unalive, and on top of doing all this unalive, hey, I'm about to rap about it, right? I'm gonna tell you when, where, what, and why. Like these people are so bold with they beef. They be on, I'm at this place, pull up. Like who is doing all of that? You said that, Mapisa, thank you for joining us. She said that girl, Alicia Andrews, is stew beef from a deep pot. And as a girl, like how you even get caught up in that? But I know how she got caught up in that. Y'all know how she got caught up in that. You know, some of us women, you know, sometimes when it get dropped on our forehead, we can't see no more. We can't think. Right? We can't think. I mean, it's just honesty. He drop it, boom. We can't think. We all out the window. We ride or die. We just doing it all. Thank goodness. Most of us have never been in one of those situations where it's about to land us in jail, you know, but it's been times when we did some stuff that we probably can look back in our life and be like, all right, I probably shouldn't have did that. All it says, I'm ignorant of all of it, but I used to have a Chicago boyfriend, and he said that you didn't get a choice, really. You were going to be in the game by the virtue of living. Yeah, and that's what I'm saying. Like, that's crazy that the kids are and people are put in that position, right? You got to pick a side. You know, when does it end? Like, and then they just go rap about it. They put it all on social media and oh my goodness, I did this to this person and this to that person. And now we done went on to I'm smoking on you and we're making smoking songs. And it is really, 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 really sad. Sad. So, I mean, she didn't just got caught up, and it is so sad because like she didn't pull the trigger. She didn't do nothing, right? And it's quiet as kept. She probably was just trying to be down for her boyfriend, but I don't know. You and him, y'all should have took y'all Chevy Cruise and y'all should have rode back to where y'all came from. I mean, she on all the cameras, y'all. That's why she couldn't deny it. She was just trying to spin it. Like, oh, we was going to the same club that he was going to. But we found out how much it cost, and so we decided not to come. We decided not to go in there. So at least they did show us the trial. They could have showed us that. They could have showed us that bond hearing yesterday. I knew it was going to be denied, just like it was. I don't know what he thought. I'm pretty sure he thought it too, but he had to go do that fight for his client. So just so everybody aware, Monday we got on our schedule. I know it's the holiday, but y'all know I can't be without y'all for no 3 days. That is out, right? I would go stir crazy without hanging with my crew. So on Monday, we are going to be doing Jarvis Butts. That is a trial that we do have coming up in the beginning of October. We are going to be going over some of the preliminary hearing stuff, some of the testimony. And the reason why these preliminary hearings are so great to hear, because this is how the case is determined, kind of like a grand jury. This is kind of how the case is determined if it goes to trial or not. Now, the one thing about these is that all the evidence, anything that they can throw against the wall, the state is going to bring, right? Not to say that some of this evidence will be presented in the actual trial, because they can start, arguing certain evidence, rule 404Bs and, bad character evidence. So some of the stuff may not come in. So some of the evidence may not come in. So it's a good thing to see the preliminary hearing, because this is the state's opportunity to throw everything against the wall. This is what we got on him. This is the video we got on him. This is why we think this. This is why we think that. And they throw it all out there. before anything could be excluded or not or ruled on or anything like that. So it's good to look at those. So we're going to look and see what stuff they have in this case. And boy, I'm telling you, talking about I don't know what you want to describe it as. It's a very disturbing case. And I'm gonna say disturbing from all parts. I'm gonna say from the family members' parts. I'm gonna say from his part. I'm gonna say from it's disturbing all the way around. You guys, we'll talk about it as we go through it, but I have a lot of mixed emotions about it. Yeah, so if you able to join us on Monday, awesome. We'll just be on for a couple hours just to kind of do it. We're gonna do like a 4-part series to get us ready for the trial. You know what? We'll know what's going on. You say, Marilda, you gonna be up in here? No holiday. I know that's right. You said I'm watching the old Betty Brocker trial on court. I've seen that. Yeah, I seen that. I seen that come up. I seen that over there on Discord. Oh, so you can watch it on Discord? I've been trying to figure out this Discord thing. I have to get with Rachel be gone because she sent me like a little tutorial of how to do it, through my phone. And I'm like, I can't figure this out because I heard they have a lot of good documents, a lot of good things on there that will assist me with kind of like running this, doing everything for you guys. Oh, awesome. Oh, what is the is it a channel or something, Ola, that you're gonna be watching it on? I'm telling you, I don't know nothing about. I don't know how to operate in there. Yeah, Marilda, like, tell us how to get this Discord thing. Look, I'm saying, wait, like, I have no clue. I do have one. I just don't know what to do on there. I don't know how to. You got to go on there and play around with it to kind of understand it. And I just haven't found like downtime to be sitting there playing games. Like, I need to know. Yeah, I seen it. They was doing that. Okay. Is it up under seeking for justice? Is that the name of it? Or do you have your own Discord on there that you run? Yeah. Yeah. Seeking for justice actually works with like every time when I okay, so you watch it on YouTube and then you're chatting on the Discord. Okay, and that's supposed to be over the weekend. I know she'll send out an alert. Okay, I'm gonna try to get on there. Marilda, I'm gonna try to work on some things for us. You may not be able to get on there this weekend, but Rachel Be Gone is the best person that showed me kind of how to do it. We'll try to work on it to see if we can get something going on. We maybe we have a tutorial on it. Maybe I'll schedule a stream and ask Rachel, can she come on here and show us all how to operate it so we can be up there with Ola and everybody else so we can know how to do it. Because I'm like, okay, if it takes too much time, I can't do it. Nope, won't do it. Yes, I will ask her. I will text her and ask her to give us a tutorial on Discord, and I'll tell her I'll set up a live stream for all taking to trial people so we can set up a Discord. We may be able to use it in order for us to talk on it while we in our trials. I think on there you can go ham. You can say whatever you want to say. So yeah, I'll ask Rachel to come hook us up and give or a therapist. Therapist is wonderful at this stuff too. So either her or therapist, I'm going to ask them over the weekend, can we set up like an hour slot? Look for the notification out there, Marilda, because I'll send it out so we can try to get up in there. Yeah, I have a Discord set up. I just don't know how to use it. So I'm like, all right, guys. Well, I will send out that notification for our Discord training as soon as I get us a teacher. Right? If not, then I'll definitely see you guys on Monday while we do our preliminary hearing for our Jarvis Buds. Definitely viewer discretion advised for that trial. Yeah, I'll probably put up the disclaimer for that one because, yeah, a little special there. Other than that, I'll send out some video clips. I know I got some stuff to send out for the Donna Adelson trial. The prosecution rested their case, so we'll be in a defense's case in chief on Tuesday, which should be very interesting and fun for us to do. Right? And other than that, you know you were in the right place today, whether you were here or whether you were there or anywhere, right? I will definitely catch you guys out here in these YouTube streets. And this is the best place, right? Where there's no filters, no fluff, just facts. So you can be the judge. All right, crew. I will see y'all over the weekend in these YouTube streets. If not, I'll see you on Monday. All right. Have a great one.